Before we begin, a quick and important disclaimer. The following comprehensive historical analysis is intended strictly for educational and entertainment purposes only. While we will be examining complex legal doctrines, sweeping legislative changes, and the profound historical evolution of family law within the United States, absolutely nothing in this presentation constitutes formal legal advice, financial counsel, or professional representation. The historical trends, case studies, and potential outcomes discussed throughout this series are drawn from historical records, sociological research, and legal archives to illustrate the shifting landscape of American jurisprudence. Viewers facing personal legal matters must never rely on historical analyses as a substitute for retained legal counsel. Always consult with a licensed, qualified attorney in your specific jurisdiction, and conduct your own rigorous due diligence before making any decisions regarding marriage, divorce, asset division, or family law proceedings. The laws vary wildly from state to state and are constantly subject to judicial revision. Consider for a moment the profound and highly controversial reality of modern American society. The single most impactful architect of the contemporary domestic landscape is not the politician, not the moral philosopher, and certainly not the marriage counselor. The true architect of the modern American family structure, the silent redistributor of immense generational wealth, and the ultimate arbitrator of domestic liberty is the divorce attorney. If we look back to the year 1969, we witness a localized legislative event that would trigger a nationwide paradigm shift. Governor Ronald Reagan signed the Family Law Act in California, effectively creating the nation's first completely no-fault divorce legislation. It is a historical irony of massive proportions that Reagan would later reportedly refer to this specific legislative signature as one of the greatest regrets of his political career. The reason for this regret lies in the astonishing, explosive aftermath of the legislation. Practically overnight, the floodgates opened, and the fundamental legal nature of the American family was irrevocably transformed from a permanent, state-enforced institution into a terminable commercial partnership. But to truly grasp how the divorce attorney went from a marginalized legal outcast operating in the shadows to a towering power broker in American high society, we must look at the dark, theatrical, and deeply flawed legal system they were forced to navigate prior to that fateful year. Before the widespread adoption of no-fault divorce, severing a legal union in the United States was an agonizing, legally treacherous, and highly dramatized process. A marriage could not simply be ended because the parties were incompatible or unhappy. The law demanded a victim and a perpetrator. To obtain a divorce, an attorney had to definitively prove legal fault. Typically meant demonstrating adultery, extreme physical or mental cruelty, abandonment, or incurable insanity. Because the burden of proof was incredibly high, a massive clandestine industry was born. Divorce attorneys of the early to mid-20th century frequently had to act as orchestrators of elaborate legal fictions. Couples who mutually desperately wanted to end their marriages were forced into a legal collusion. Attorneys would implicitly direct their clients to stage theatrical scenes of infidelity. An entirely separate underground economy of private investigators, paid witnesses, and staged hotel room photographs flourished just to satisfy the rigid demands of the family court system. The divorce attorney in this era was often viewed by the broader legal establishment with deep suspicion and disdain, relegated to the less prestigious tiers of the legal profession because the work was inherently messy, deeply personal, and steeped in moral scandal. However, the legal revolution of the 1970s shattered this restrictive framework, and in doing so, it elevated the divorce attorney to unprecedented heights of power and societal influence. When the requirement to prove fault evaporated, the sheer volume of marital dissolution skyrocketed, fundamentally altering the demographic and economic makeup of the United States. The arena of conflict shifted almost entirely away from proving moral failure and moved directly onto the battlefield of brutal, high-stakes economics and the psychological warfare of child custody. Suddenly, the divorce attorney could no longer merely be a purveyor of evidence. They had to evolve into a highly sophisticated forensic accountant, a ruthless corporate negotiator, and a masterful strategist regarding human psychology. As the decades progressed through the 1980s and 1990s, the nature of American wealth itself became infinitely more complex. Attorneys were no longer just dividing a modest family home and a checking account. They were forced to untangle vast stock portfolios, complex executive compensation packages, hidden offshore assets, intellectual property rights, and intricate pension plans. The divorce attorney became the gatekeeper to billions of dollars transferring hands every single year, effectively operating a shadow economy that rivaled major corporate mergers in its financial complexity and devastating personal consequences. This brings us directly to the monumental promise of this masterclass and the exact problem it will solve for you today. Millions of Americans enter into the legal contract of marriage deeply blinded by the cultural narrative of romance, remaining completely ignorant of the fact that they are signing a highly binding, incredibly complex commercial agreement dictated by centuries of legal precedent. When the prospect of dissolution arises, individuals find themselves utterly defenseless against a legal machine they do not understand, facing potential outcomes that can annihilate their financial future and fundamentally sever their relationship with their children. In this exhaustive, multi-part historical deep dive, we are going completely behind the curtain of the American family court system. We are going to decode the specific historical strategies, the landmark case studies, and the relentless evolution of the divorce attorney to show you exactly how the rules of domestic dissolution were written, manipulated, and perfected over the last century. By comprehensively understanding the historical trends that birthed concepts like equitable distribution, community property, and rehabilitative alimony, you will no longer be walking blind in the landscape of family law. We will systematically dissect how the most elite attorneys in modern history learned to leverage forensic discovery to uncover hidden wealth, how they utilize psychological evaluations to establish dominant positions in custody battles, and how the shifting definitions of marital versus separate property have continuously redefined the financial reality of the middle and upper classes. You are going to learn how the legal system views your income, your debts, your business assets, and your very earning potential through the cold, calculating lens of historical precedent. This is not merely a recounting of the past. It is the absolute critical unlocking of the invisible legal framework that surrounds your life right now. By mastering the historical context of the divorce attorney, you will acquire a level of legal and financial literacy regarding the domestic sphere that the vast majority of the population lacks, empowering you to understand the gravity, the risks, and the profound legal mechanics of the American household. To truly comprehend these profound legal mechanics, we must examine the immediate aftermath of the no-fault revolution. The moment the requirement to prove adultery or cruelty was stripped away from the family court system, a massive vacuum of legal strategy was created. The battleground instantly shifted from the bedroom to the bank account. Prior to this shift, if an attorney could not prove fault, the divorce was simply denied, and the financial status quo remained frozen. But once the exit doors were thrown wide open, the legal profession realized that the true value of their representation was no longer in securing the divorce itself, but in controlling the terms of the financial untangling. This historical pivot fundamentally birthed the modern forensic approach to family law. Attorneys who previously relied on private investigators taking clandestine photographs suddenly had to learn how to read complex tax returns, scrutinize corporate balance sheets, and trace hidden international wire transfers. The divorce attorney transformed into a financial auditor, armed with the terrifying power of state-sanctioned subpoenas. Consider the historical transition from common law title systems to the modern concept of equitable distribution. In the early to mid-20th century, the legal framework was brutally simple and often devastatingly unfair. If a house or a bank account was solely in the husband's name, the court generally presumed it belonged exclusively to him regardless of the wife's non-financial contributions to the household. The historical trends show that this rigid title-based system left millions of dependent spouses completely destitute after decades of marriage. Recognizing the systemic economic failure, state legislatures and the American legal establishment began adopting equitable distribution laws largely influenced by the Uniform Marriage and Divorce Act of the 1970s. This meant that the court was now mandated to divide marital property fairly, though not necessarily equally. But fairness is an incredibly subjective legal standard. It is an abstract concept that requires aggressive interpretation. And this is precisely where the divorce attorney found their most lucrative and powerful historical role. They became the sole interpreters of what constituted a fair division of an entire lifetime of accumulated assets. Let's examine a historical case study that illustrates this massive transfer of power. In the 1980s, the definition of marital property began to expand exponentially in courtrooms across the nation. It was no longer just the physical house or the physical cash in the local bank. The courts began ruling that pensions, retirement accounts, and eventually even professional degrees and medical licenses could be assigned a tangible financial value and divided upon divorce. The attorney was no longer just a legal representative, they became an appraiser of human capital. They began hiring actuaries and vocational experts to testify about the future earning capacity of a spouse. They built an entirely new legal infrastructure designed specifically to project future wealth and demand a percentage of it in the present day. This required a level of sophisticated financial modeling that previously only existed on Wall Street, but was now being deployed in local county courthouses across the United States. Imagine, if you will, a scenario to ground this in our current reality. Imagine a couple named Michael and Sarah living in the United States in the year 2026. Michael starts a seemingly small e-commerce business in his garage 3 years after they are married, while Sarah maintains her corporate job to provide their health insurance and a stable baseline income. Over the next 5 years, Michael's business explodes into a multi-million-dollar enterprise. In a historical fault-based system, the argument would center entirely around who wronged whom. But in our modern 2026 legal landscape, the divorce attorney steps into this scenario as a forensic surgeon. The attorney representing Sarah will not simply ask for half of the current bank balance. They will launch a massive discovery process demanding every single ledger, every hidden cryptocurrency wallet, every future vendor contract, and every intellectual property valuation associated with Michael's company. They will argue historically grounded concepts like commingling of assets and sweat equity, asserting that the business could not have survived its infancy without Sarah's foundational financial support. The primary weapon the modern attorney wields in these scenarios is the legal process known as discovery. This is the mandated exchange of information where neither party is legally permitted to hide financial realities. The historical evolution of discovery in family court is staggering. What used to be a request for a few pay stubs and a paper deed has morphed into demands for terabytes of digital data. Modern divorce attorneys issue sweeping subpoenas to banks, brokerage firms, credit card companies, and even social media platforms to piece together a digital forensic footprint of spending and asset accumulation. They look for the classic historical red flags of financial infidelity, such as unexplained cash withdrawals, sudden loans to mysterious friends, or the sudden depreciation of a business valuation just prior to the divorce filing. The attorney constructs a highly complex financial narrative designed specifically to convince a judge that the opposing party is attempting to defraud the marital estate. The potential outcomes of these financial battles dictate the socioeconomic status of families for generations. When an attorney successfully argues that a specific asset is separate property, rather than marital property, they effectively shield massive amounts of wealth from division. This requires tracing the exact origin of every single dollar back to its source before the marriage occurred. It is a grueling, painstaking process of reviewing decades of financial history. The legal standards governing these financial traces are notoriously complex and highly dependent on the specific jurisdiction and the presiding judge's interpretation of historical case law. A single misstep by an attorney in classifying a stock portfolio or a real estate investment can result in a devastating financial loss for their client. Furthermore, attorneys had to develop specialized mechanisms like the Qualified Domestic Relations Order to legally siphon funds from federal pension plans and 401k accounts without triggering catastrophic early withdrawal tax penalties. The process of this exhaustive financial audit is inherently adversarial and deeply intrusive. Clients often report feeling completely exposed and violated as their attorney, and the opposing counsel dissect their entire financial history line by line. Every purchase, every investment, every financial failure is suddenly placed under a judicial microscope. The attorney must prepare their client for this brutal psychological exposure. They must manage their client's expectations regarding what the law actually considers fair versus what the client feels they emotionally deserve. This requires the attorney to act as a harsh reality check, constantly grounding the client in the cold hard facts of historical precedent rather than the heated emotions of the present conflict. The most effective attorneys in modern history are those who can completely detach the emotional narrative of the failed marriage from the strict mathematical reality of the asset division. While the financial untangling of the American marriage represents a multi-billion-dollar industrial complex, it is incredibly only half of the battlefield that the modern divorce attorney must master. The division of money, property, and future earnings, as brutal as it is, fundamentally follows the logical rules of mathematics, tax codes, and historical financial precedent. But what happens when the asset being divided is not a stock portfolio, a business valuation, or a piece of real estate but human life? What happens when the historical shift from fault to no-fault divorce collided with the shifting cultural definitions of motherhood, fatherhood, and psychological well-being? The financial warfare we have just explored pales in absolute comparison to the devastation and the complex legal strategies deployed when attorneys turn their attention away from the bank accounts and aim their formidable legal weapons directly at the children, setting the stage for a psychological arena so dark and so legally convoluted that it required the creation of an entirely new class of institutional experts to navigate it. To understand the sheer gravity of this psychological arena, we must first recognize the complete historical collapse of the tender years doctrine. For over a century, American courts operated under a highly presumptive and rigidly gendered legal framework. The tender years doctrine essentially dictated that during the formative years of a child's life, the mother was the natural and absolute optimal custodial parent. Under this historical precedent, the divorce attorney representing a father had virtually no viable legal path to secure primary custody, unless they could definitively prove the mother was demonstrably unfit through severe neglect or profound moral failing. The burden of proof was astronomical, and therefore custody trials were relatively rare. But as the cultural revolutions of the 1970s and 1980s completely reshaped the American workforce and the fundamental roles of men and women, the courts were forced to adapt. The sweeping historical trends demanded gender neutrality in family law, leading directly to the universal adoption of the best interests of the child standard. This seemingly progressive and undeniably well-intentioned legal standard, however, unintentionally created a massive structural vulnerability. By making the child's best interests the paramount consideration, the courts effectively removed the objective biological presumption and replaced it with an entirely subjective, highly fluid psychological interpretation. The moment custody became subjective, it became deeply contestable. The divorce attorney suddenly realized that to win control over the children, and consequently control over the massive financial obligations of child support, they needed to completely redefine the narrative of parenthood. They could no longer rely on rigid legal statutes, they had to rely on the subjective behavioral analysis of their opponents. This historical pivot birthed the era of the forensic custody evaluation and transformed the divorce attorney into a psychological tactician. Attorneys began deploying armies of court-appointed psychologists, licensed clinical social workers, and behavioral therapists to conduct exhaustive, deeply invasive assessments of both parents. The legal strategy was no longer about proving legal fault, it was about proving psychological superiority. The family court, which was fundamentally designed to resolve contractual disputes, was suddenly forced to act as a massive diagnostic clinic analyzing personality disorders, attachment styles, and parenting methodologies. Imagine, if you will, a highly realistic scenario unfolding right now in the year 2026. Consider an American couple named Robert and Jessica currently navigating the grueling machinery of a modern family court. In 2026, the historical presumption in many jurisdictions heavily favors a 50-50 shared parenting arrangement. However, if Jessica wishes to relocate to another state, or if Robert seeks primary physical custody, the best interests of the child standard is immediately triggered. The attorneys representing Robert and Jessica will instantly deploy incredibly aggressive forensic strategies. They will not merely interview the parents. The modern divorce attorney will subpoena the children's pediatric records, depose school teachers, analyze years of private text messages, and meticulously scrutinize every single social media post to construct a highly weaponized psychological profile of the opposing parent. Every minor parental misstep, a missed soccer game, a late drop-off, a frustrated text message sent in the heat of an argument is meticulously cataloged, entirely stripped of its original context, and presented to a judge as definitive evidence of profound psychological instability. In this 2026 landscape, the attorney utilizes complex psychological concepts as blunt legal instruments. We see the constant historical weaponization of theories, such as parental alienation syndrome, where one attorney accuses the opposing parent of systematically brainwashing the child against their client. Defending against such allegations requires an enormous expenditure of legal and financial resources. The attorneys will demand that Robert and Jessica submit to rigorous psychological testing, such as the Minnesota Multiphasic Personality Inventory, which consists of hundreds of highly probing questions designed to detect hidden psychopathology. The results of these tests, which are often highly subject to interpretation by competing hired experts, are then debated in open court. The divorce attorney in these specific historical scenarios is essentially cross-examining human nature itself, attempting to convince a judge whose legal training involves absolutely no psychological background to make a permanent life-altering decision based on conflicting behavioral data. The potential outcomes of these psychological custody wars are almost always devastating to the families involved, regardless of who actually wins the legal judgment. The historical data clearly demonstrates that the introduction of behavioral experts into the adversarial legal system dramatically increases the duration and the financial cost of a divorce. Families routinely liquidate their entire life savings, tap into home equity lines of credit, and exhaust college funds simply to pay the staggering hourly rates of the attorneys and the psychological evaluators. The marital estate, which took decades to carefully build, is rapidly consumed by the very process of attempting to divide it. The divorce attorney therefore occupies a deeply paradoxical role. They are simultaneously the fierce protector of their client's parental rights, primary financial beneficiary of the systemic conflict. They are forced by the very structure of the legal system to escalate the animosity to secure the best possible legal positioning. Furthermore, the psychological toll extracted by this adversarial process permanently alters the family dynamic. When a child is forced to endure interviews with court-appointed strangers, when they are asked to express a preference between their parents, and when they witness the intense financial and emotional destruction of their household, the trauma is deeply embedded. The modern legal system, despite its constant reliance on the phrase "the best interests of the child," frequently operates in a manner that fundamentally damages the child's immediate stability. The attorney must navigate this profound ethical minefield daily, balancing the aggressive legal demands of their adult client against the collateral psychological damage inflicted upon the children involved. They operate in a legal ecosystem where the most effective tactical maneuver is often the most emotionally destructive one. This historical evolution from a rigid title-based system to a subjective, psychologically driven battleground has pushed the American family court system to the absolute brink of total collapse. The courts are massively backlogged, the judges are overwhelmed by the sheer volume of psychological data, and the public is increasingly horrified by the financial ruin inherent in the process. The sheer unsustainability of litigating human emotion has forced the legal profession to desperately seek alternative avenues of resolution. But as the most elite divorce attorneys realized that open court warfare was becoming far too unpredictable and far too destructive, they did not simply surrender their power. Instead, they orchestrated yet another massive historical pivot. They moved the entire battlefield completely out of the public eye and into a highly secretive, entirely unregulated shadow legal system, where the rules of evidence no longer apply, and where billions of dollars and the fate of millions of children are decided behind heavily locked doors. This invisible infrastructure was designed to fix the system, but it inadvertently created something far more terrifying. This invisible infrastructure is known formally as alternative dispute resolution, but in the high-stakes reality of modern family law, it functions as a completely privatized shadow court. In the late 1980s and early 1990s, the American public court system was buckling under the sheer weight of skyrocketing no-fault divorce rates. Public family court dockets were hopelessly congested. A couple facing the dissolution of their marriage could easily wait years just to get a single 15-minute hearing before an exhausted judge regarding temporary child support or emergency custody orders. Recognizing this massive systemic paralysis, state legislatures across the nation championed mediation and arbitration as the ultimate legislative solution. It was aggressively marketed to the American public as a gentler, more civilized, and far less adversarial way to untangle a broken marriage. The fundamental promise was that couples could sit at a collaborative conference table instead of a hostile courtroom, negotiate their future with dignity, and save tens of thousands of dollars in protracted legal litigation fees. But the most elite divorce attorneys in the country looked at this newly created, completely unregulated landscape and immediately recognized an unprecedented opportunity to consolidate their power and permanently shield their wealthiest clients from public scrutiny. They engineered the explosive rise of the private judge and the binding arbitration industry. The concept of private judging represents one of the most controversial and highly consequential historical trends in American jurisprudence. In highly populated jurisdictions across states like California and Texas, the law explicitly allows divorcing parties to bypass the public court line and effectively hire a retired judge to preside over their entire case. This private adjudicator is paid an exorbitant hourly rate, often exceeding $1,000 an hour, directly by the divorcing parties to act with the full legal authority of a sitting state superior court judge. On the surface, this appears to be a mere administrative convenience for those who can afford it. But examine the underlying legal mechanics, and the terrifying reality of this system emerges. These private judicial proceedings take place in luxurious corporate boardrooms entirely shielded from the public record. There are no court reporters making trial transcripts available to the press or the public. There are no public galleries where citizens can observe the application of the law. When an elite divorce attorney successfully moves a high-asset case into this shadow system, they are essentially purchasing absolute, impenetrable secrecy. If massive financial fraud, hidden offshore banking accounts, complex tax evasion strategies, or deeply disturbing domestic abuse allegations are uncovered during the forensic discovery process, the private nature of the arbitration virtually ensures that these explosive revelations never see the light of public day. Furthermore, the private judge is fundamentally economically dependent on the elite divorce attorneys who continuously select them for these lucrative assignments. This creates a deeply concerning historical dynamic, known in legal sociology as the repeat player effect. The private adjudicator has a profound vested financial interest in remaining favorable, or at least highly accommodating, to the powerful law firms that supply their continuous caseload. If a private judge develops a reputation for ruling too harshly against the clients of a specific powerhouse law firm, that firm will simply cease to hire them for future arbitrations. The attorney holds the ultimate leverage over the judge. Imagine a highly realistic scenario unfolding in the year 2026, involving a high-net-worth American couple named Thomas and Olivia. Thomas is a senior executive at a major technology conglomerate with unvested stock options and deferred compensation packages worth tens of millions of dollars. Olivia has spent the last 15 years sacrificing her own career to raise their 3 children and manage their extensive complex real estate portfolio. When the marriage inevitably collapses, Thomas immediately retains a top-tier divorce attorney who adamantly insists on utilizing a private mediator and a retired private judge. The explicit legal strategy is to keep the corporate stock valuations, the executive compensation structures, and the intimate details of their lifestyle completely out of the public eye. Olivia is quickly thrust into a grueling psychological process known as shuttle diplomacy. In this highly specialized form of alternative dispute resolution, Thomas and Olivia are placed in entirely separate, windowless conference rooms for 10 to 12 hours a day. The private mediator shuttles back and forth between the 2 rooms, carrying incremental settlement offers and relentless, carefully calculated legal threats. The divorce attorney in this isolated environment does not need to convince a public jury or a heavily scrutinized elected judge. Instead, they utilize the weapon of acute psychological exhaustion. They barrage the opposing party with incredibly complex financial spreadsheets, competing expert witness reports, and worst-case legal scenarios deliberately designed to create massive panic and total decision fatigue. Olivia is systematically worn down in an environment where her own attorney is billing $800 an hour, Thomas is spending $1,000 an hour on his counsel, and the private mediator is demanding an additional $1,000 an hour. The sheer financial burn rate of the day is terrifying. The intense psychological pressure to sign a binding, irrevocable financial agreement, simply to stop the devastating financial hemorrhaging, becomes entirely overwhelming. The historical data from the last 2 decades clearly reveals that this form of coerced mediation often produces legal settlements that massively favor the party with the greater financial endurance and the higher tolerance for risk. Because these private arbitration systems are legally binding and virtually impossible to appeal, the traditional protective safeguards of the American justice system are completely circumvented. A party who signs away their fundamental legal rights to future stock earnings or accepts a deeply flawed, intentionally deflated business valuation under the extreme duress of a 14-hour closed-door mediation session has almost absolutely no legal recourse to overturn that signature in a public appellate court. The appellate courts historically refuse to intervene in private contracts signed during mediation. The modern divorce attorney has therefore successfully bypassed the unpredictable nature of open court and guaranteed a highly controlled, absolutely silent outcome. They have transformed the ultimate emotional dissolution of the American family into a highly sanitized, brutal corporate merger where human leverage is traded like a raw financial commodity and justice is determined by who can afford to keep the meter running the longest. But while this impenetrable shadow court system serves as the ultimate protective shield for the ultra-wealthy and the corporate elite, the modern divorce attorney relies on a completely different and far more mathematically ruthless legal mechanism to process the vast majority of the American middle class. For the everyday citizen who cannot afford a private judge, the legal system utilizes an inescapable, automated financial algorithm that legally garnishes future labor, a deeply entrenched historical precedent so incredibly unyielding that it effectively indentures one spouse to the other for decades without any hope of bankruptcy protection. This concept of legally indenturing one spouse to another brings us to the profound and often devastating historical evolution of spousal support, universally known as alimony, and the rigid algorithms governing child support. To truly understand the terrifying power the modern divorce attorney wields in this specific financial arena, we must first examine the deep historical roots of these legal doctrines. Alimony originated in English common law during an era when a woman had absolutely no legal right to own property or generate her own independent income. Under coverture laws, a husband assumed total legal control over his wife's existence, and in exchange, the law imposed a strict, inescapable duty upon him to provide for her financial maintenance. When the no-fault divorce revolution of the 1970s swept across the United States, and as women entered the workforce in unprecedented numbers, the foundational logic of lifelong alimony should have theoretically collapsed. Instead, the legal establishment, driven heavily by the strategies of elite divorce attorneys, simply rebranded the concept. They transitioned from the historical duty of absolute maintenance to the modern, highly contested concepts of rehabilitative support and the preservation of the marital standard of living. This subtle linguistic shift gave the modern divorce attorney an incredibly powerful new weapon. The battlefield was no longer about sheer survival, it was about maintaining a lifestyle. The court systems across the United States eventually attempted to standardize this massive transfer of wealth by implementing complex, state-mandated mathematical formulas and support calculators. On the surface, these algorithms appear purely objective, simply taking the income of party A and the income of party B to generate a monthly payment. However, the elite divorce attorney knows that the variables plugged into this algorithm are completely subjective and highly susceptible to aggressive manipulation. The attorney does not fight the calculator, they fight the inputs. They initiate a brutal, exhaustive audit of the entire marital existence to artificially inflate or deflate the perceived needs and the perceived ability to pay. Imagine a highly realistic scenario taking place in the United States in the year 2026. Consider a couple named David and Emily. For 15 years, David worked as a highly compensated sales executive, while Emily managed the household and raised their children. A year before the divorce is filed, David is unexpectedly laid off during a massive corporate restructuring. He takes a job in a completely different industry, making less than half of his previous salary. In a logical, non-adversarial system, the support calculations would be based on his current, actual reality. But in the modern family court system, Emily's divorce attorney will immediately deploy a devastating legal tactic known as the imputation of income. The attorney will aggressively argue that David's current unemployment or underemployment is deliberate, characterizing it as a malicious strategy to starve Emily out of the marital estate. To prove this, the attorney will hire a forensic vocational evaluator. This specialized expert will analyze David's historical earning capacity, review his resume, cross-reference open job postings in his geographic area, and present a highly polished report to the judge stating that David possesses the capacity to earn his previous high salary. Based entirely on this hypothetical, speculative report, the judge can legally impute that phantom income to David. The court will order David to pay spousal and child support based not on the money he is actually depositing into his bank account, but on the money the court believes he should be making. David is immediately trapped in a mathematical impossibility. He is legally mandated to surrender a percentage of a ghost income, frequently leaving him with negative cash flow simply to maintain his basic living expenses. The divorce attorney has successfully weaponized David's own historical success against him, transforming his past achievements into a crushing future liability. The potential outcomes of this imputed income strategy are financially catastrophic. When David inevitably falls behind on these impossible payments, he crashes directly into the brutal reality of the United States Bankruptcy Code. The divorce attorney explicitly relies on the fact that domestic support obligations are treated fundamentally differently than any other type of consumer debt. If David accumulates massive credit card debt, medical bills, or unsecured personal loans, he can file for Chapter 7 or Chapter 13 bankruptcy and have those debts legally discharged, granting him a fresh financial start. But spousal support and child support arrears are absolutely non-dischargeable in bankruptcy. They survive the bankruptcy process completely intact, continuously accruing terrifying levels of statutory interest. The divorce attorney has effectively engineered an inescapable debt trap. Furthermore, the enforcement mechanisms for these specific debts rival the collection powers of the Internal Revenue Service. If a spouse falls behind on court-ordered support, the opposing attorney does not simply send a collection letter. They petition the court to suspend the debtor's driver's license, revoke their professional medical or legal licenses, intercept their federal tax refunds, and seize their passports. Ultimately, the attorney can file a motion for civil contempt, requesting that the judge issue an active warrant for the debtor's arrest. We have historically reached a point in modern American jurisprudence where debtors' prisons, legally abolished in the 19th century, have effectively been resurrected within the confines of the family court system. Individuals who cannot meet these mathematically impossible, historically calculated obligations are routinely incarcerated until they can magically produce a purge payment, a scenario entirely orchestrated by the relentless pressure of the opposing counsel. This brings us to the exhausting process of defining the marital standard of living. To maximize the spousal support award, the attorney must prove to the court exactly how the couple lived during the final years of the marriage. This requires the divorce attorney to transition into a lifestyle auditor. They will subpoena years of credit card statements to meticulously calculate the historical average spent on vacations, country club memberships, luxury vehicle leases, private school tuitions, and fine dining. They construct a sprawling, comprehensive spreadsheet of consumption. The historical irony is that maintaining one household at this elite standard of living previously required the entirety of the marital income. By splitting the household in two, that same income must now cover double the overhead, double the mortgages, and double the utility bills. It is a mathematical certainty that the standard of living must drastically decline for both parties. Yet, the legal framework, pushed to its absolute limits by aggressive attorneys, frequently attempts to force the higher-earning spouse to fully subsidize the historical lifestyle of the lower-earning spouse, effectively guaranteeing the financial ruin of the primary breadwinner. The divorce attorney leverages this terrifying financial reality to force highly favorable settlements long before a trial ever occurs. The mere threat of an imputed income evaluation, coupled with the absolute dread of non-dischargeable debt and potential incarceration, is usually more than enough to coerce a spouse into signing away massive portions of their retirement accounts or forfeiting their equity in the family home, just to lower the monthly support obligation. They are forced to trade their entire accumulated past just to buy back a fraction of their future freedom. But what happens when the financial estate is completely exhausted? What happens when there are no more retirement accounts to liquidate, when the home equity has been entirely consumed by legal fees, and when the future earning capacity has been maximally garnished? When the mathematical formulas reach their absolute limits and the money ceases to flow, the most elite and ruthless divorce attorneys do not simply close the file. They pivot to an entirely different, far more dangerous domain, crossing the line from civil litigation into the terrifying realm of criminal allegations, weaponizing the very laws designed to protect the most vulnerable in order to execute the ultimate strategy of total annihilation. The transition from civil litigation into the terrifying realm of criminal allegations marks the darkest and most controversial evolutionary leap in the history of the modern divorce attorney. In legal circles, this highly aggressive maneuver is often quietly referred to as the silver bullet strategy. To understand how this strategy functions, we must first examine the historical context of domestic violence legislation in the United States. Throughout the late 20th century, advocacy groups correctly identified a massive systemic failure. Victims of severe domestic abuse were routinely trapped in incredibly dangerous situations because the standard legal process was simply too slow. In response, state legislatures across the country revolutionized the legal code to prioritize immediate physical safety over standard procedural due process. They created the Emergency Protective Order, a legal mechanism designed to be deployed instantly. This legislative change was absolutely necessary to save lives, but it simultaneously created an unprecedented vulnerability within the family court system. Elite divorce attorneys instantly recognized that the evidentiary standards required to obtain an emergency protective order were vastly lower than the standards required in a standard civil trial. Because these emergency orders are typically granted in what the legal system calls an ex parte hearing, the judge only hears from one side. The accused party is not present, they are not allowed to mount a defense, and they are completely unaware that the proceeding is even taking place. The judge, facing the potential outcome of denying an order and having a tragedy occur, will historically err on the side of extreme caution and grant the temporary order based entirely on a single sworn affidavit. The elite divorce attorney realized that if they could successfully inject an allegation of fear or abuse into a standard divorce proceeding, they could instantly bypass months of tedious civil negotiation and secure a devastating immediate tactical advantage. Imagine, if you will, a scenario unfolding right now in the year 2026. Consider an American couple named Christopher and Amanda. Their marriage is dissolving not due to violence but due to severe financial stress and fundamental incompatibility. Christopher currently holds the higher income and intends to fight for 50-50 shared custody and to remain in the marital home. Amanda consults an aggressive litigation firm. The attorney reviews the historical trends of their specific county courthouse and realizes that in a standard civil proceeding, Christopher has a very strong case. Therefore, the attorney constructs an entirely different legal narrative. A heated verbal argument from 4 months ago, involving raised voices and a slammed door, is meticulously documented, completely stripped of its original context, and framed in a sworn affidavit as a terrifying instance of psychological abuse and a latent physical threat. The execution of this strategy is a masterclass in psychological warfare and legal timing. The divorce attorney will typically file the ex parte motion late on a Friday afternoon. The element of surprise is absolute. Christopher is suddenly served with legal documents by armed local law enforcement officers at his place of employment. He is informed that he is legally barred from returning to his own property. He is prohibited from contacting his wife, and most devastatingly, he is instantly stripped of all access to his children. He is given 10 minutes to pack a single bag of clothing under police supervision, and is escorted off his own property. In the span of a single afternoon, the divorce attorney has fundamentally altered the entire reality of the case without a single piece of objective evidence being cross-examined. Let us meticulously break down the immense leverage the attorney has just secured. By obtaining the emergency order, the attorney has instantly granted Amanda exclusive use and possession of the marital residence, forcing Christopher to immediately secure temporary housing, thereby doubling his living expenses. Furthermore, the attorney has established de facto sole physical custody of the children. Because family courts heavily favor the status quo, the longer Christopher is kept away from the children, the stronger Amanda's permanent custody case becomes. But the most punishing aspect of this strategy is the fundamental shift in the burden of proof. In a standard civil divorce, both parties start on equal footing. But once a protective order is in place, Christopher is effectively presumed guilty in the eyes of the family court. He is instantly placed on the defensive, forced to prove a negative, forced to prove that he is not a threat. The financial multiplication caused by this tactic is staggering. Christopher can no longer rely solely on a family law attorney. He must immediately retain a criminal defense attorney to handle the protective order hearing, essentially fighting a two-front legal war. He is bleeding capital at an exponential rate. The historical data regarding these tactical filings reveals a massive systemic overload. Courthouses across the United States are completely overwhelmed by the sheer volume of protective orders filed perfectly concurrently with divorce petitions. The absolute tragedy of this historical trend is that legitimate victims of horrific abuse are frequently lost in the bureaucratic noise. Their genuine cries for help buried beneath a mountain of tactical filings orchestrated by attorneys seeking leverage in property disputes. The court system simply does not possess the resources or the time to effectively separate a brilliant, aggressive legal maneuver from a genuine emergency in the span of a 15-minute initial hearing. The modern divorce attorney operating at the highest levels understands that the mere threat of this silver bullet is often enough to force a total surrender. During closed-door settlement negotiations, the attorney might subtly imply that if the opposing party does not agree to a highly unfavorable financial settlement, their client will have no choice but to formally document their deep feelings of unsafety. It is a legalized form of extortion, utilizing the massive, terrifying machinery of the state as a weapon of mass financial destruction. The accused spouse, facing the total annihilation of their public reputation, the potential loss of their professional career due to the stigma of an active restraining order, and the immediate severing of their relationship with their children, will frequently sign away hundreds of thousands of dollars in assets just to make the allegations disappear. But what happens when the stakes are so astronomically high, and the allegations are so deeply complex, that the accused spouse refuses to surrender? What happens when the court is faced with two highly articulate, deeply entrenched parents, backed by massive legal teams, both presenting perfectly contradictory narratives of abuse and alienation? When the family court judge realizes they cannot possibly decipher the objective truth through competing affidavits and highly choreographed courtroom testimonies, they execute a maneuver that changes the entire trajectory of the American family. They strip the power away from the parents entirely, suspend the standard rules of evidence, and hand the fate of the children over to a completely unmonitored, highly compensated, and virtually immune third-party investigator. This third-party investigator is officially known within the American legal ecosystem as the guardian ad litem, or the forensic custody evaluator. To comprehend the terrifying absolute power these individuals wield, we must first trace the historical trends that mandated their creation. In the late 1980s and early 1990s, family court dockets experienced an unprecedented explosion of highly complex psychological warfare. Judges whose primary educational background was strictly limited to legal theory and procedural law suddenly found themselves forced to act as clinical psychiatrists. They were tasked with deciphering deeply entrenched allegations of narcissistic personality disorder, untangling complex webs of coercive control, and determining the validity of suppressed trauma. Recognizing that they were fundamentally unequipped to make these clinical diagnoses, the judicial system orchestrated a massive delegation of authority. They created a legal bypass, allowing the court to officially outsource its fact-finding responsibilities to private mental health professionals and specialized attorneys. The introduction of the forensic evaluator fundamentally altered the entire strategic playbook of the elite divorce attorney. The primary target of legal persuasion instantly shifted away from the judge and directly onto the evaluator. But the legal mechanics governing these third-party investigators are deeply controversial and historically dangerous. When a judge appoints a guardian ad litem or a custody evaluator, they simultaneously grant them a legal shield known as quasi-judicial immunity. This means that under historical legal precedent, if the evaluator conducts a profoundly negligent investigation, completely ignores exculpatory evidence, or writes a final report fueled by blatant personal bias, the devastated parents are almost entirely barred from suing that evaluator for malpractice. The state protects the evaluator with the exact same impenetrable immunity that protects the judge. Furthermore, the moment the evaluator steps into the case, the traditional foundational rules of legal evidence are completely suspended. In a standard American civil or criminal trial, the rule against hearsay is a sacred pillar of due process. You cannot introduce a rumor or a second-hand statement into evidence without giving the accused the right to directly cross-examine the original accuser. However, in the realm of the custody evaluation, hearsay is not just allowed, it is the primary currency of the investigation. The evaluator is granted unrestricted authority to interview the children's school teachers, pediatricians, soccer coaches, and neighbors behind closed doors. They can collect anonymous tips, listen to unsubstantiated neighborhood gossip, and factor all of this unverified information into a binding psychological profile. The accused parent is entirely stripped of their constitutional right to confront their accusers in open court. Imagine a highly realistic and incredibly common scenario unfolding in the United States right now in the year 2026. Consider an American couple named Daniel and Rachel. They are locked in a bitter, protracted dissolution involving significant assets and 2 young children. Rachel's attorney, utilizing the aggressive strategies we previously analyzed, has filed a massive motion alleging that Daniel exhibits severe anger management issues and utilizes alienating behaviors to distance the children from her. Daniel's attorney aggressively counters, claiming Rachel suffers from undiagnosed borderline personality traits that render her an erratic and unsafe primary caregiver. The presiding judge, facing 2 massive, completely contradictory narratives and a terrifying potential outcome if they guess incorrectly, immediately halts the legal proceedings. The judge issues an order appointing a highly sought-after forensic psychologist to conduct a comprehensive family evaluation, mandating that Daniel and Rachel split the staggering financial cost of the investigation. This introduces an entirely new, inescapable financial nightmare into the 2026 marital dissolution. The forensic evaluator does not work for the state, they are a private contractor. They immediately demand a massive upfront retainer, frequently exceeding $20,000 or $30,000, simply to open the file. The divorce attorneys on both sides will meticulously prep their clients for this grueling process, essentially training them on how to survive a psychological audit. Daniel and Rachel are subjected to intense, multi-day clinical interviews. They are forced to complete hundreds of pages of standardized psychological inventories, such as the Minnesota Multiphasic Personality Inventory. Every single answer is statistically weighted and analyzed against historical baselines of psychopathology. The evaluator then schedules unannounced home visits to observe the parents interacting with the children in their natural environment. The psychological pressure of these visits is absolute. The parents are trapped in a panopticon, acutely aware that every single interaction, every meal prepared, and every disciplinary action taken is being meticulously documented and clinically judged. If a child throws a normal developmental tantrum during the observation, the evaluator might document it as evidence of the parent's inability to maintain a stable environment. The children themselves are pulled out of their elementary school classrooms and subjected to closed-door interviews with the evaluator. They are asked highly leading questions about their parents' behaviors, inadvertently forcing them into devastating loyalty binds where they feel compelled to curate their answers to protect the parent they fear most, or the parent they feel the most pity for. After months of exhaustive data collection, the evaluator distills this massive intrusion into a final comprehensive written report, usually spanning 70 to 100 pages. In the historical landscape of modern family law, this document is the atomic bomb. While the report is technically classified as a mere recommendation to the court, the undeniable historical trend is that family court judges rubber stamp and adopt the findings of the court-appointed expert in the vast majority of cases. The judge simply does not possess the administrative time to review the thousands of pages of raw interview notes and psychological test data. They read the executive summary, and they issue their final ruling based almost entirely on the evaluator's conclusions. Therefore, the divorce attorney who successfully manipulated the subjective perceptions of the evaluator has effectively won the entire war without ever having to argue the facts before a jury. If the final report heavily favors Rachel, the potential outcomes for Daniel are catastrophic. His divorce attorney must now attempt the nearly impossible historical feat of discrediting a court-appointed expert witness. To execute this defense, Daniel's attorney must hire what is known as a rebuttal expert. This requires Daniel to liquidate another $20,000 from his rapidly vanishing retirement accounts to pay a completely different forensic psychologist, simply to read the first psychologist's report and testify that the methodology was fundamentally flawed. The courtroom is transformed into a highly academic, incomprehensibly expensive proxy war between competing mental health professionals, entirely funded by the collapsing marital estate. The legal arguments shift away from the actual facts of the family dynamic and descend into esoteric debates over the Daubert standard of admissibility, peer-reviewed clinical methodologies, and the statistical error rates of personality tests. The parents are reduced to mere spectators while their financial future and their fundamental right to raise their children are debated in the cold, clinical language of psychiatric diagnostics. But what happens when this sprawling, unregulated psychological data collection inevitably breaches the walls of the courthouse? What occurs when the highly sensitive, intensely private medical and psychiatric records compiled during these brutal evaluations are deliberately leaked out of the sealed family court system by a rogue attorney seeking ultimate leverage? As we plunge deeper into this historical analysis, we must examine the terrifying legal frontier where the divorce attorney realizes that the most valuable asset in the entire marital estate is no longer the physical property or the corporate stock. The true leverage lies in the weaponized, perfectly documented blackmail material harvested during the custody evaluation, setting the stage for a campaign of public destruction so absolute that it forces the entire American legal system to question the very limits of privacy and the First Amendment. The weaponization of this highly sensitive psychiatric data relies on a deeply terrifying historical loophole regarding the intersection of family law and the First Amendment. In the United States, family court records involving minors, especially brutal psychological evaluations and allegations of abuse, are generally heavily redacted or entirely sealed from public view. The court recognizes that this information is extraordinarily volatile. This sealed file becomes what legal scholars call the shadow record. It contains the absolute darkest, most clinically dissected flaws of the American citizen. Every past trauma, every prescribed medication, every desperate text message sent during a mental health crisis is neatly organized into a searchable, devastating dossier. But the elite divorce attorney operating in the modern era understands that a sealed court document is completely useless if their primary goal is absolute leverage. To break a deeply entrenched, highly funded opponent, the attorney must find a way to circumvent the judicial seal and inject this toxic shadow record directly into the public bloodstream. This strategic maneuver has historically evolved into a highly coordinated campaign of reputational destruction. Imagine a profoundly realistic scenario unfolding in the fiercely competitive corporate landscape of the United States in the year 2026. Consider a highly successful public figure named Marcus. Marcus is the chief executive officer of a publicly traded technology firm, and his entire net worth, as well as his social standing, is entirely dependent on corporate board approval and public shareholder trust. His wife, Victoria, has retained a notoriously aggressive divorce litigation boutique. During the mandatory psychological evaluations we previously discussed, Victoria detailed several intense verbal altercations, characterized Marcus as deeply narcissistic, and submitted historical evidence of a brief, intense struggle with prescription medication from a decade ago. Inside the sealed courtroom, Marcus has a fighting chance to defend against these claims using his own rebuttal experts. The legal outcome is uncertain. Therefore, Victoria's attorney decides that waiting for a judicial ruling is strategically inefficient. They opt for the nuclear option. The attorney orchestrates a calculated, highly deniable leak to the press or digital media platforms. In the year 2026, information travels with lethal velocity. The attorney does not simply hand the sealed evaluation to a reporter, as that would result in immediate disbarment and criminal sanctions. Instead, they utilize a complex network of public relations crisis firms, anonymous encrypted drops, and seemingly accidental procedural filings that temporarily place unredacted information onto the public electronic docket before being swiftly removed. By the time the family court judge notices the procedural error and reseals the document, the damage is already irreversibly done. The information has been scraped by digital journalists, aggregated by financial news outlets, and weaponized across social media. The moment the shadow record goes public, Marcus is forced into an unwinnable battle against the First Amendment. The historical trends regarding American constitutional law are incredibly clear. The doctrine of prior restraint fundamentally prevents a judge from ordering a news organization to stop publishing information they have already obtained, even if that information was illegally leaked from a sealed family court file. Freedom of the press historically supersedes the privacy rights of the divorcing citizen. Marcus cannot sue the newspapers for publishing his psychiatric history. His only theoretical legal recourse is to prove exactly which member of the opposing legal team leaked the document, an investigative standard that is practically impossible to meet. The potential outcomes of this media orchestration are incredibly fast and financially devastating. Before Marcus can even file an emergency injunction in the family court, the corporate board of his technology firm calls an emergency weekend session. Fearing a massive drop in share prices and a public relations catastrophe, they enact the moral turpitude clause in his employment contract. Marcus is summarily terminated, stripping him of his primary income source, his unvested stock options, and his professional identity. In a matter of 48 hours, the divorce attorney has successfully annihilated the entire financial foundation of the opposing party without ever having to argue a single point of law in front of the presiding judge. The court of public opinion acts as the ultimate, unregulated arbitrator. This tactic is essentially a sophisticated, entirely legalized form of extortion. The most elite attorneys will frequently preview this destruction before it ever happens. During a highly tense mediation session, the attorney might explicitly state that if Marcus does not immediately agree to a completely lopsided financial settlement and sign over total custody of the children, the legal team will unfortunately have to file a highly detailed motion regarding his past substance abuse in the open public record. They will express deep mock sympathy for the media storm that will inevitably follow. Marcus is faced with a terrifying binary choice. He can fight for a fair division of assets and risk total societal and professional exile, or he can sign away his life savings to buy his own privacy. Faced with the immediate destruction of his career, the vast majority of individuals in these historical case studies choose to surrender the assets. They pay the ransom. This terrifying dynamic fundamentally alters the sociological makeup of the American legal system. The divorce attorney ceases to be a mere legal representative and transforms into a powerful public relations architect. They manage the flow of information, they dictate the terms of public survival, and they wield the power to completely cancel an individual from American high society. We have seen these historical trends repeatedly over the last 2 decades, where high-profile divorces of politicians, corporate titans, and entertainment figures play out not in the courtroom, but on the front pages of digital tabloids. The legal filings are deliberately drafted not to persuade the judge, but to provide salacious, damaging quotes for the evening news cycle. The family court system, originally designed to privately and equitably divide a household, has been hijacked and converted into a public execution square. The systemic cost of this weaponization is astronomical. The American public is continuously fed a stream of highly distorted, strategically manipulated domestic drama, entirely eroding the collective faith in the sanctity and fairness of the judicial system. The sheer terror of being subjected to this level of public exposure traps millions of citizens in miserable, highly toxic, and potentially dangerous marriages. They look at the terrifying landscape of modern divorce, they witness the utter destruction of their peers, and they calculate that the emotional cost of remaining in a broken home is vastly cheaper than the absolute devastation of facing a modern divorce attorney. They choose the silent suffering of a failed marriage over the public slaughter of the family court. The power of the elite divorce attorney is not merely confined to destroying the present reputation and dividing the current assets of the divorcing couple. The most sophisticated, aggressive legal minds operating in this space have realized that the current marital estate is frequently just the tip of the financial iceberg. Once they have conquered the checking accounts, the real estate, and the public reputation, they turn their formidable legal weapons toward the ultimate prize. They begin to analyze the bloodlines. They bypass the husband and the wife entirely and launch a massive, unprecedented legal assault directly against the generational wealth of the extended family, aiming to shatter irrevocable trusts and seize inheritances from grandparents who are completely unaware that their legacy is about to be legally plundered. To understand how this legal plunder is orchestrated, we must first examine the historical concept of the irrevocable family trust. For generations, the wealthy elite of the United States relied on these complex legal structures as impenetrable fortresses. The fundamental premise was simple. If a grandparent placed millions of dollars into an irrevocable trust for their child, that money legally belonged to the trust itself, not the individual child. Therefore, if the child eventually married and subsequently faced a dissolution of that marriage, the opposing attorney theoretically could not touch those assets because the divorcing spouse did not possess legal ownership of the principal. This was the absolute bedrock of generational wealth preservation. However, the elite divorce attorney of the modern era views this legal fortress not as an immovable object, but as a highly complex lock waiting to be systematically picked. Over the last 3 decades, historical trends in family law appellate courts demonstrate a relentless, highly coordinated campaign to erode the protections of the family trust. Utilizing incredibly sophisticated forensic accounting and aggressive legal theories, such as the alter ego doctrine and the piercing of the corporate veil. The primary weapon the modern divorce attorney utilizes to shatter these generational fortresses is the forensic tracing of commingled funds. The attorney understands that human nature and financial convenience frequently override strict legal and fiduciary boundaries. Let us imagine a highly realistic scenario unfolding in the American legal system in the year 2026. Consider a family where a patriarch named Richard established a multi-million-dollar discretionary trust for his son James. James has been married to his wife Sarah for 14 years. When the marriage inevitably collapses, Sarah retains a highly aggressive litigation boutique. James and his attorney immediately point to the trust document, confidently declaring that the generational principal is completely shielded from the proceedings. But Sarah's attorney does not attack the trust document directly. Instead, they launch a massive multi-year forensic audit of every single historical banking record from the entire marriage. They are searching for a single fatal fiduciary mistake. They are meticulously looking for the exact moment James used a distribution from the family trust to pay the property taxes on the marital home, or the moment he used trust funds to finance a joint family vacation, or perhaps the day he deposited a trust dividend check directly into a shared marital checking account before moving it elsewhere. In the ruthless mathematical logic of the modern family court system, the moment separate, protected generational wealth is mixed with marital assets, or used to actively benefit the marital lifestyle, its absolute legal protection is instantly compromised. The divorce attorney will aggressively argue that by commingling the funds, James essentially transmuted the protected trust money into divisible marital property. Furthermore, if James exercised too much operational control over the supposedly independent trustee, frequently dictating exactly when and how he received distributions, Sarah's attorney will execute the alter ego theory. They will attempt to prove to the presiding judge that the trust is a mere legal fiction, a sham entity designed solely to hide marital assets, and demand that the entire principal be exposed to equitable distribution. The execution of this strategy requires the divorce attorney to aggressively expand the legal battlefield far beyond the divorcing couple. To definitively prove their case, the attorney must issue sweeping, draconian subpoenas directly to the elderly parents, the grandparents, and the professional corporate trustees managing the estate. Richard, who has never been a party to his son's marital dispute and who assumed his financial privacy was absolute, is suddenly dragged into the brutal public arena of the family court. He is legally compelled under the threat of contempt to turn over his private tax returns, his comprehensive estate planning documents, the Schedule K-1 forms of his private businesses, and decades of privileged correspondence with his financial advisors. He is forced to sit for grueling multi-day depositions where a hostile opposing counsel aggressively cross-examines him regarding his true intentions behind establishing the trust decades ago. The psychological terror inflicted upon the extended family during this process is profound and entirely intentional. The divorce attorney utilizes this massive, intrusive legal harassment as the ultimate form of indirect leverage. They calculate that a patriarch like Richard, facing the terrifying audit of his entire life's work and the exposure of the family bloodline to public scrutiny, will often instruct his son to simply settle the divorce under highly unfavorable terms. Richard will frequently agree to pay Sarah's exorbitant financial demands out of his own pocket, simply to quash the subpoenas and stop the terrifying legal assault on the family infrastructure. But one might ask, what happens if the family anticipated this exact nightmare and utilized the ultimate preemptive legal strike, the prenuptial agreement? For decades, the American public has been sold the comforting narrative that a prenuptial agreement is an absolute, unbreakable shield against the financial ravages of divorce. The historical reality, however, is far more complex and dangerous. The elite divorce attorney views a prenuptial agreement exactly the same way they view a family trust. It is merely a procedural hurdle. The historical trends in litigation clearly show that an entire subspecialty of family law has evolved solely for the purpose of breaking these specific contracts. When a high net worth couple enters the family court system in 2026, the very first tactical maneuver by the financially disadvantaged spouse is often to file a massive motion to entirely invalidate the prenuptial agreement, plunging the case into years of preliminary appellate litigation before the actual divorce asset division even begins. The attorney attacks the premarital agreement on multiple, highly aggressive fronts simultaneously. They will argue the legal concept of unconscionability, attempting to prove that the terms of the contract were so fundamentally unfair at the exact time of signing that no rational human being would have agreed to them without being subjected to extreme emotional or financial duress. They will meticulously investigate the precise timeline of the signing process, searching for historical evidence that the document was presented merely days before the wedding ceremony, thereby denying their client the adequate time to secure independent, competent legal counsel. Furthermore, they will initiate a massive forensic discovery process focused entirely on the financial disclosures made prior to the marriage. If the attorney can prove that the wealthier spouse hid even a single minor asset, undervalued a family business, or failed to disclose a specific tax liability a decade ago, they will argue that the entire agreement was signed under fraudulent pretenses and must be completely discarded by the court. The sheer financial cost of defending a prenuptial agreement in this modern landscape is staggering. The wealthy spouse is forced to spend hundreds of thousands of dollars in current legal fees simply to prove the validity of a document originally designed to save them money. Even more devastating, the court will frequently order the wealthier spouse to pay the legal fees of the attorney who is actively trying to destroy the agreement, utilizing the concept of temporary alimony to fund the very lawsuit attacking the protected wealth. The attorney attacking the agreement operates on a ruthless, highly effective calculation. They know that the wealthy spouse, facing the prospect of years of brutal litigation just to validate the contract, will frequently capitulate. They will offer a massive, multi-million-dollar cash settlement that completely bypasses the terms of the original prenuptial agreement, just to make the litigation stop. The divorce attorney has effectively extorted a fortune by merely threatening to dismantle the legal shield. This brings us to a terrifying, overarching realization regarding the entire historical evolution we have systematically analyzed throughout this masterclass. From the destruction of the fault-based system, to the rise of the psychological custody war, the implementation of the shadow court of private judging, the algorithms of endless debt, and the relentless calculated assault on generational wealth, a singular, undeniable truth emerges. The American family court system is not broken. It is not malfunctioning. It is operating with terrifying absolute precision. It is a highly optimized, self-sustaining economic engine designed to extract the maximum possible amount of accumulated wealth from the American household and transfer it directly into the legal, psychological, and financial institutions that oversee the dissolution. But as the American public slowly awakens to this devastating historical reality, and as the middle and upper classes face total financial extinction at the hands of this machinery, a profound cultural backlash is brewing. The ultimate question is no longer how the divorce attorney operates, but what happens when the society they have systematically engineered decides to fundamentally rewrite the very rules of human partnership to permanently escape their jurisdiction. This societal rewrite is currently manifesting as one of the most profound demographic and legal shifts in American history. We are witnessing the era of the great opt-out. For decades, sociologists and cultural commentators have observed the plummeting marriage rates across the United States and frequently attributed this massive decline to shifting moral landscapes, a prolonged adolescence, or a cultural fear of commitment. But when we view this phenomenon through the cold, calculating lens of historical legal studies, a completely different and far more logical reality emerges. The modern generations, specifically millennials and Generation Z, grew up watching the absolute financial slaughter of their parents within the family court system. They witnessed the exhaustive forensic audits, the devastating psychological warfare of custody evaluations, and the relentless generational wealth extraction orchestrated by the elite divorce attorneys. In response, they are making a highly rational, mathematically calculated decision to simply boycott the state-sanctioned contract of marriage entirely. They have realized that the only guaranteed method to completely neutralize the terrifying power of the family court system is to never voluntarily submit to its jurisdiction in the first place. But human beings inherently still desire lifelong partnership, cohabitation, and the strategic merging of resources to survive in a complex economy. Therefore, historical trends in 2026 show a massive, unprecedented rise in alternative, highly privatized legal structures designed to completely bypass the family law establishment. Imagine a highly realistic scenario involving an American couple named Alex and Morgan in the year 2026. They are deeply committed to one another, they plan to purchase significant real estate together, and they intend to build a family unit. However, they absolutely refuse to sign a state marriage license, knowing it is effectively a blank check handed to the judicial system. Instead, they hire a corporate attorney, not a family law attorney, and they form a domestic limited liability company. They structure their romantic and financial partnership exactly like a high-stakes corporate joint venture. Alex and Morgan become equal, legally defined shareholders in this corporate entity. The LLC purchases the primary residence, the LLC holds the diversified investment accounts, and the LLC manages the operational budget of their daily domestic lives. The absolute genius of this structural strategy lies within the intricately drafted operating agreement. Instead of relying on the unpredictable, highly subjective historical precedents of equitable distribution or community property laws dictated by a family court judge, Alex and Morgan dictate their own absolute financial reality from day one. The operating agreement outlines specific, mathematically rigid protocols for monthly capital contributions to cover the household overhead, strictly defined rules for profit distributions from shared investments, and most importantly, an ironclad protocol for corporate dissolution. If the romantic relationship eventually fails, there is absolutely no legal avenue for a massive, intrusive discovery process. There is no need for forensic accountants to desperately argue over the historical standard of living, and there is absolutely no statutory basis for one party to demand rehabilitative alimony or lifetime spousal support. The dissolution of their partnership simply triggers a strictly defined corporate unwinding. The shared assets are liquidated or bought out according to a predetermined mathematical formula, completely bypassing the family court docket. If a dispute arises regarding the valuation of the home or the division of the corporate bank account, it is not handled by an exhausted family law judge. It is legally mandated to be sent to private, binding commercial arbitration. By aggressively utilizing established corporate contract law, Alex and Morgan have effectively stripped the elite divorce attorney of their highly specialized weaponry. A family law expert cannot weaponize a domestic violence allegation or a claim of emotional cruelty to secure a better share price in a standard corporate dissolution. The intense emotional volatility of a romantic breakup is entirely and legally severed from the cold, mathematical reality of the asset division. Furthermore, we are seeing the aggressive, systematic weaponization of decentralized finance as a direct, historical countermeasure against the perceived overreach of the American family court system. Historically, the divorce attorney relied heavily on the absolute subpoena power of the state to compel central banks, major brokerage houses, and traditional financial institutions to freeze marital assets and turn over decades of historical ledgers. But the fundamental landscape of wealth holding in 2026 has fractured entirely. High net worth individuals are systematically moving massive portions of their liquid capital into self-custody digital assets and highly complex decentralized finance protocols. They are utilizing advanced cryptographic multi-signature wallets where the digital keys required to move the funds are distributed across multiple international legal entities and geographical jurisdictions that hold no extradition or reciprocity treaties with the United States family court system. The potential outcomes of this massive capital flight are deeply frustrating to the traditional legal establishment. When a modern, highly compensated divorce attorney attempts to audit a marital estate that is heavily concentrated in decentralized assets, They hit an impenetrable mathematical wall. The family court judge can issue a sweeping court order demanding the immediate surrender of these digital assets, but if the defending spouse claims to have lost the cryptographic seed phrase, or if the assets are actively locked in a programmatic smart contract that absolutely requires the cryptographic consent of an offshore third-party trustee to execute a withdrawal, the traditional enforcement mechanisms of the state completely fail. The court cannot hold a decentralized blockchain network in civil contempt. They cannot electronically garnish an immutable smart contract. The massive, terrifying machinery of the state collection apparatus, which historically resurrected debtors' prisons for unpaid spousal support, is rendered entirely obsolete by open-source cryptography. The wealth effectively vanishes from the jurisdictional reach of the divorce attorney, creating a vast, untraceable shadow economy of untouchable capital. Even the deeply emotional, highly contested battlefield of child custody is being systematically pre-engineered to avoid the psychological warfare we analyzed in previous segments. Historical trends indicate a massive surge in complex, legally binding co-parenting agreements established long before conception ever occurs. Individuals are utilizing collaborative legal frameworks to definitively map out educational rights, stringent medical decision-making protocols, and exact physical custody schedules before the child is even born. They are establishing private, irrevocable educational trusts that automatically fund the child's developmental needs independently of the parent's personal cash flow, thereby completely eliminating the need for the brutal, algorithm-driven child support calculators mandated by the state. The overarching goal of this movement is to build an infrastructure so highly detailed and so legally binding from the very beginning that the entirely subjective best interests of the child standard never needs to be debated in an open courtroom by competing forensic psychologists billing $1,000 an hour. The American divorce attorney began the 20th century as a marginalized legal figure forced to orchestrate staged, theatrical photographs in dingy motel rooms. But they relentlessly evolved into the ultimate, undisputed arbiters of domestic power. They mastered complex forensic accounting, they successfully weaponized subjective psychological evaluations, they built an impenetrable shadow court system of private judges, and they launched devastating, highly coordinated legal assaults on generational wealth. They engineered a legal machine so incredibly efficient at extracting capital from human conflict that they eventually became victims of their own terrifying historical success. By making the cost of dissolution financially and psychologically unsurvivable for the average citizen, they forced the American public to innovate, to adapt, and to eventually abandon the foundational institution of state-sanctioned marriage altogether. The family court system is slowly but inevitably being starved of its primary economic resource, as citizens actively migrate toward corporate structures, decentralized wealth preservation, and privatized parenting contracts. But the systematic extraction of wealth from the American citizen never truly stops. It simply migrates to a new, more vulnerable sector of society. We have now completely decoded the historical destruction of the American family and the brilliant, ruthless attorneys who profited from it. But what happens when the very institution designed to keep you alive, the American hospital system, adopts these exact same ruthless forensic billing practices to legally seize your family home while you are lying in a hospital bed fighting for your own life?